Equuscorp was a finance company, which consequently spent a lot of its time chasing people for money, including through the courts. They had an in-house legal team, but they also engaged an external firm, which was Wilmoth Field Warne. They had a client service agreement in place, and it was an arrangement where the client and the firm shared some of the risks in the situation, so the payment to the firm was in some ways dependent on their success in chasing down defaulters. Things went along well for a couple of years, but then the relationship between solicitor and client broke down. There was a dispute as to whether Wilmoth Field Warne had undertaken the work they were engaged to do, and there was a dispute as to what the firm should be paid. Most of those issues were really complex and need not concern us here. The client service agreement, however, did not contain an explicit statement to the effect that the solicitors had to comply with the instructions of the client, Equuscorp. So when the matter went to trial, Equuscorp argued that such a term should be implied into the contract. The judge agreed. Justice Burns said, putting to one side the exceptional position where the client's instruction contravenes a solicitor's supervening duty to the court or the solicitor's ethical responsibilities, I have no doubt that the retainer of a solicitor includes a term requiring compliance with instructions. But even so, the instruction must be one which is proper for the client to give, and absent some express term to the contrary, is limited to instructions as to the steps which are to be taken in pursuing the litigation in question. That such a term is omitted from the deed of costs is probably explicable from the fact that it goes without saying. This case teaches us fundamental things about the relationship between solicitor and client. It is inherent in that relationship that the solicitor must execute the client's lawful instructions, provided they do not conflict with the solicitor's higher duty to the court. This responsibility is so central to the relationship that it doesn't even need to be explicitly stated in a costs agreement. It is so obvious that it goes without saying.